ये बताइए ना आप इसके
तो
ऊपर।
देखिए बात ये है कि वो 26 अमेंडमेंट या उसके कॉन्सिक्वेंसेस तो हम चैलेंज कर रहे हैं, हम उसमें फिलहाल जाना नहीं चाहते.
We are not taking to there. We are asking for the bench only. We are not asking you to argue on the merits of the case.
We are only saying that on the judicial side, kindly consider this as important for saving the basic features that a full court should sit and decide. For example, the same situation arose back in 1997. When a judicial order was passed that the court should hear the cases under which challenge was made to the appointment of the then Chief Justice of Pakistan. And a bench was formed, bench was directed to be made under Justice Siddiqui, who was head of that bench. The senior Judge Siddiqui, or the senior puisne judge at that time, Justice Mian, Ajmal Mian, recused from there. But nobody questioned the judicial parts of a bench of the Supreme Court to form to direct formation of the full court. So that is a precedent. Otherwise, when this matter was before them, it was challenged even that Chief Justice has not formed this bench. How come you have formed the bench? The answer came that on the judicial side it could always be done. But if it has to be done on the administrative side, it has to be Chief Justice.
अगर इस तरह समझ लें खान साहब, जुडिशल से आपकी बात मान लेते हैं, फर्ज करें अगर आपकी बात मानते हुए हम ऑर्डर कर देते हैं कि तमाम जजेस जितने भी सुप्रीम कोर्ट के हैं, दे शैल बी मेंबर ऑफ द कॉन्स्टिट्यूशनल बेंच, वुड यू बी सेटिस्फाइड?
Member of the Constitutional
ये
Bench.
सारे तमाम जितने जजेस हैं सुप्रीम कोर्ट के, will you be satisfied or not?
नहीं, इसमें मेरी गुजारिश होगी, be satisfied if all 16 judges.
16 को ले लेते हैं, अगर हम ऑर्डर कर देते हैं कि ये 16 जजेस कॉन्स्टिट्यूशनल बेंच का हिस्सा बने, फिर आप सेटिस्फाई होंगे?
हिस्सा बना कॉन्स्टिट्यूशनल बेंच का जो तस्वर है वो आपने 26वीं तरमीम के तहत दिया है. अगर 26वीं
हमने नहीं किया, पार्लियामेंट ने किया, हम पे ना डालें. पार्लियामेंट
उसी को तो हम चैलेंज कर रहे हैं.
ठीक है, हो सकता है आप सक्सीड कर जाए, हो सकता है आप सक्सीड कर जाए या ना कर जाए.
एक मिनट के लिए आप 191A को भूल जाइए, फॉर द रीजन दैट वो तो अंडर चैलेंज है ना सर. तो आप ये देखिए, हम वहां खड़े हैं जहां
अगर 191A को भूल जाएं तो फिर तो कॉन्स्टिट्यूशन बेंच का तस्वुर ही खत्म हो गया. फिर बाय वी आर सिटिंग हियर,
कॉन्स्टिट्यूशनल बेंच इंटरनल बेंच
खत्म हो गया. उसका देयर इज नो कॉन्स्टिट्यूशन बेंच.
खान साहब सुनिए, then there is no Supreme Court in the country today. There is no Supreme Court.
That's what we are saying. The Supreme Court is there.
नहीं है तो फिर
ये constitution
अगर आप 199 को अगर आप 191A को नहीं मानते हैं, फिर तो ये बेंच खत्म हो गया.
बेंच क्या, फिर there is no Supreme Court in the country.
आप कह रहे हैं उसको हम भूल लेते हैं, चले हम भूल लेते हैं, आपकी बात मानते हैं, हम भूल जाते हैं, एक साइड पे रख लेते हैं, फिर तो ये बेंच खत्म हो गया.
खत्म नहीं होता. It's still a bench of the Supreme Court.
This is the creation of Article 191A1 and A4.
Even today Supreme Court is under Article
फिर आपको
191.
पार्लियामेंट को अप्रोच करना पड़ेगा कि एक फुल बेंच बना के एक
कोर्ट बना है, पहले तो सुप्रीम कोर्ट
पैदा हो सकती है, but things have to be resolved judicially. और इसको जुडिशली, वरना अगर हम इससे बाहर निकल गए तो फिर हमारी जुडिशरी बिकम्स टोटली मीनिंगलेस. तो हु विल सपोर्ट? बात यहाँ पर जो हम कर रहे हैं, ये 26th अमेंडमेंट इज एन अटैक ऑन द इंडिपेंडेंस ऑफ जुडिशरी. दैट्स व्हाट माय आर्गुमेंट. इसको प्रोटेक्ट करना, इस कोर्ट को और इसकी इंडिपेंडेंस को, ये सुप्रीम कोर्ट का अपना काम है. और इसलिए हमारी सबमिशन है, आप कॉन्स्टिट्यूशन बेंच नहीं, आप 8 मेंबर बेंच है इस ऑनरेबल कोर्ट का, और आपने हमारी सबमिशन को एक्सेप्ट करते हुए 16 मेंबर बेंच यानी फुल कोर्ट दैट एग्जिस्टेड द टाइम ऑफ पासिंग 26th अमेंडमेंट, उसका जुडिशियल ऑर्डर पास करना है.
इग्नोरिंग
इस बेंच को चीफ जस्टिस ने या जो प्रैक्टिस एंड प्रोसीजर कमेटी ने नहीं बनाया,
नहीं बनाया.
ये बेंच उसके तहत बना ही नहीं है. तो अगर आप उसको नहीं मानते हैं, फिर तो इस बेंच का वजूद ही खत्म हो गया. फिर हम ऑर्डर कर ही नहीं सकते.
हम तो आपके सामने जुडिशियल ऑर्डर सीख रहे हैं.
देखिए ना,
ये बेंच नहीं कर सकेगा.
191 को इग्नोर करें कि वो जुरिस्डिक्शन जो अंडर द कॉन्स्टिट्यूशन सिर्फ कॉन्स्टिट्यूशनल बेंच को है, हम बाकी जजेस को वो मतलब कन्फर करें बाय ऑर्डर ऑफ दिस कोर्ट.
This
to hear these petitions.
तो 191A जो है वो तो फिर
उसको फिर
infructuous हो गया ना, it has become redundant and before hearing you it amounts to making it redundant unless you argue the whole case at the relevant time and we will reach to the
वो बाबत हमारी
conclusion
है, बाद में
whether it
जो
is
भी
against the basic structure
we
or
may
what are
agree
the
or-
defects in the amendment,
वो
that
तो-
would be a different story.
तो सर
But
करेंगे।
right now you know that you are very senior counsel, Article 5 of the Constitution. Loyalty to the state is the basic duty of every citizen. Obedience to the Constitution and law is the inviolable obligation of every citizen, wherever he may be, and of every other person for the time being within Pakistan.
Yes.
So 191A is a part of Constitution presently, unless it is treated otherwise or struck down at the final stage of the case. But right now, it is the part of the Constitution. And you say that ignore it and make the full court. How within that jurisdiction we can do this? I'm asking this for last many
सर मेरी गुजारिश ये है कि मैं बारहा अर्ज ये कर रहा हूँ कि आपको 1 मिनट के लिए ये तस्वर करना पड़ेगा कि आज कल 26वीं तरमीम पास हुई, अब इस पर कोई एक्ट ऑन नहीं हुआ। तो अब देखना ये है कि ये जो 26वीं तरमीम है क्या ये आइन के बेसिक स्ट्रक्चर के मुताबिक है कि नहीं।
that will be seen at the relevant time when you will argue the case on merits.
इसलिए
But
one-
right now, this is question of bench. You are asking us to do something which can be do under the Constitution. Please satisfy on this point.
सर वो हम उस पर सेकंड स्टेज पे आएंगे। मैंने पहले ही कहा ये जो कुछ भी मैं सबमिट कर रहा हूँ ये फुल कोर्ट फॉर्मेशन के हवाले से है, क्योंकि इम्पोर्टेंस ऑफ द सब्जेक्ट बिफोर योर लॉर्डशिप इज सच इम्पोर्टेंट वन दैट ओनली हाफ ऑफ दैट फुल कोर्ट इज एट प्रेजेंट बिफोर अस। We are only seeking कि please also include the other learned 8 judges who were judges of this honorable court at the time when 26th Amendment was passed. This is nutshell of my submission. और इसके लिए I am trying to take precedent. आपके पाकिस्तान के प्रेसिडेंट क्या है?
बताइए।
अब मैं आपको ब्रीफली सारे प्रेसिडेंट बता देता हूं जिनमें हमेशा फुल कोर्ट बनी है। जहां भी इंपॉर्टेंट कॉन्स्टिट्यूशनल क्वेश्चंस अराइज हुए हैं वहां पर फुल कोर्ट बनी है। ये तकरीबन 70 साल की बात है। अब देखिए पहला जो इस किस्म का केस है वो आप सब जानते हैं, फेडरेशन ऑफ पाकिस्तान वर्सेस तमीजुद्दीन खान, PLD 1955 Federal Code 240. It was consisting of full court. At that time, Supreme Court's sanction strength was 5 judges. One incident I'll just point out for the sake of history. One of the learned judges was, however, not available. Justice Shahabuddin. He had been given an assignment as additional governor of East Pakistan. In his place, they completed the quorum of the strength of 5 by taking an ad hoc judge. At that time, the Chief Justice of Lahore High Court, Justice S.A. Rahman. So again, full 5-member bench decided this case. Then, sir, next case, which I'll be referring to, I'll give the list also tomorrow.
Yes, yes.
Jubindra Kishore versus Province of East Pakistan. This was relating to the Viaries of East Pakistan State Acquisition Tenancy Act. A very important question.
Citation क्या है इसका?
Citation, sir, PLD 1957, Supreme Court 9. By that time, the 56th Constitution had come into existence. It was again full court.
What is the third
The
case?
third case, State versus Doso, PLD 1958, Supreme Court 533.
553,
533.
right?
This
533.
533.
Okay.
At this time, there were only 4 judges of the Supreme Court. One of the judges' vacancy was there. So this was a case heard by 4-member bench. Full court for all intents and purposes. That was the available judges of the Supreme Court. Then next, very important case, again, question of interpreting the constitution, was Fazlul Qadir Chaudhary versus Abdul Haq. PLD 1963. Thank you. PLD 1963, Supreme Court 486. In this case, a statute was struck down because it was against the Constitution, and at that time it was provided under the Constitution that a minister cannot be a member of the Parliament in a presidential system. But in the garb of resolving the difficulties, the provision of the 62 Constitution, they allowed the ministers to retain their membership of the Parliament. This was struck down by the Supreme Court, by a full court, at that time 5-member Supreme Court. Then, sir, next important case in this regard is Maulana Maududi versus Government of West Pakistan. PLD 1964, Supreme Court 673, in which Supreme Court set aside the notification by the government declaring Jamaat Islami as unlawful association. Again, a case, constitutional case of national importance. Then, sir, next case I'll be referring, Province of East Pakistan versus Sirajul Haq Patwari. PLD 66, Supreme Court 854. Again, all 5-member bench decided relating to the election of certain functionaries under the basic democracies model. So therefore, again, a full court. Then, sir, next important case is Asma Janani versus Government of Punjab. PLD 1972, Supreme Court 139.
एक मिनट रिपीट कर दीजिए प्लीज.
Yes, sir.
रिपीट कर दीजिए PLD.
Yes, 1972, Supreme Court 139.
ये आसमा जिलानी होगी ना.
This was where the martial law and the consequential acts which were performed by General Yahya Khan was declared as illegal, unconstitutional, and invalid. The 5-member court and all 5 judges sat there. The next important case is the state versus Ziaur Rahman. PLD 1973, Supreme Court 49. Again, 5-member bench, all 5 sat to decide this case. Then next, Begum Nusrat Bhutto versus Chief of Army Staff. PLD 1977, Supreme Court 657. Sir, at that time, the strength of the court was 9 judges, including the Chief Justice. All 9 of them heard and decided this case. And next case is Federation of Pakistan versus Haji Muhammad Saifullah Khan. PLD 1989, Supreme Court 166. At that time, the strength of the Supreme Court was 12 judges, including the Chief Justice. They all heard this case together, and in which it was decided, upheld the judgment of the Lahore High Court, but did not allow the election to take place, allowed the election to take place and did not restore the government of Mr. Junejo. Then, sir, next important case in this regard is about the dissolution of the assembly headed by Benazir Bhutto Sahaba. It is Khwaja Ahmad Tariq Rahim versus Federation of Pakistan. PLD 1992, Supreme Court 646. At that time, the strength of the Supreme Court was 12 judges, and all 12 heard this case. Then, sir, next case is Muhammad Nawaz Sharif versus Federation of Pakistan. PLD 1993, Supreme Court 473. At that time, the full court consisted of, or available judges were 11 judges. This decision was taken by all 11 members of the court at that time. Then, sir, this 90s precedent. Then, sir, Malik Asad Ali's case. Malik Asad Ali versus Federation of Pakistan. PLD 1998, Supreme Court 161. In my humble submission, this is one of the most relevant cases in the context of Pakistan, because there the question was what should whether the appointment of then Chief Justice was valid or not, and therefore all the judges available, because at that time there were 5 or 6 other judges. Chief Justice did not become part of, or was not made part of this bench. And so Justice Ajmal Mia also recused from there. So these 10 judges were the available judges and formed a full court. And that's what they explained. Because they even explained in this judgment that 7 judges could not sit on the bench and had recused, and therefore only 10 members are available as full court. Then next case, Chief Justice Iftihar Muhammad Chaudhry versus President of Pakistan. PLD 2010, Supreme Court 61. Now, this was decided by 13-member full court. Others had recused. Actually, the Chief Justice's case, so he could not sit, and so were some other judges not available. So the available judges were 13 judges. It was formed a full court, and case was decided by this full court consisting of 13 members. Then, sir, next important case was Bashar Hassan versus Federation of Pakistan. इसमें सिंध हाई कोर्ट बार का केस है। कहाँ पर है? So, sorry, next case which I like to refer to is Sindh High Court Bar Association versus Federation of Pakistan.
Petition बताएं.
Sindh High Court Bar Association versus Federation of Pakistan. PLD 2009 Supreme Court 879. Decided by full court of 14 judges. At that time, this may kindly be taken as precedent, there were about 15 other judges who had been appointed under provisional constitution order. So the question was whether they could form part of the bench full court or not. So the answer was that since the very provisional constitution order was under challenge, and those appointed under that, they could not sit under it, and therefore only 14 judges who had not taken oath under PCO were available and was considered as full court and decided the matter. Then, sir, next, Mubashir Hassan versus Federation of Pakistan. PLD 2010,